right. Welcome. Today, our talk is going to be if the diagnosis is dementia, what it means, and things we want you to know. My name is Kim Hegwood. I am an estate planning elder law attorney. I love my seniors. I tell everybody I miss my grandparents. So getting to hang out with other people's grandparents is just the best part of getting up in the morning. So I'm just going to kind of walk you through some different things that I think are really important for someone to know, and hopefully that will give us all the information or give you as much information as possible. And I'll try to do this as quick. I tried to cut these slides down, but it still seemed like a lot. So one of the things we want you to know is, kind of talk about just briefly is what is dementia? It's an illness that affects the brain, results in the death of many brain cells. Symptoms include memory loss, disorientation. It does impair everyday activities, and it progressively worsens over time. And so an Alzheimer's disease is a type of dementia, and most people don't realize it, but dementia is not a normal part of aging, okay? And so a lot of people think, oh, I'm getting older, it's just a natural progression, but it's not. Statistics-wise, as many as 6 million Americans have dementia. By 2050, that number is projected to be 14 million. Alzheimer's disease is the most common form of dementia and is the 6th leading cause of death in the US. And in 2016, 16 million people provided 18.2 million hours of unpaid, get that's unpaid assistance to a person with dementia. And since 2000, deaths from dementia have increased by 89%. So we really have to watch for this kinds of stuff. When you start thinking about care options, you're looking at, in-home care. Medicare does have some home health services that they pay for. Maybe you're moving in with the kids or the kids are moving in with you, even worse, probably. Home medical systems, medical alerts, door alarms. We talk to clients about all those things. There's now adult daycare. And just when you thought, it couldn't get any worse, right? They now have a place for you to go. Assistance in living facilities, continuing care retirement communities, and then hospice services. And so when you're thinking about care, a lot of these things come into play. And so depending on where you're at, what stage and things like that of your dementia care will depend on how many or what stage or what options are going to be available for you. When you think about professionals to contact for help, there's a lot of very good aging life care professionals. And then your area agency on aging, they do family care support programs, some transportation services, home delivered meals, senior centers, some personal care home and support services, and then there's some possibility of maybe you can get the nursing home waiver program. And then really, truly that neurologist or neuropsychologist, because that's the professional. That's the one that's going to be talking about really diagnosing what type of dementia that the person has, because there's lots of different types. And then you want a good elder law attorney. See, I even put Hegwood Law Group right there so you couldn't miss us. And so when you see a neurologist or a neuropsychologist, you want someone that specializes in dementia care because you want to get the appropriate, accurate diagnosis. Because there's so many different types of dementia, you want to make sure that you're getting treated for the correct one. So because a proper diagnosis gets you the right treatments. Today they can kind of slow the disease progression, but they can't stop it. And so, and a lot of people think, if you've got dementia, it's all the same. Not true. And then depending on the type of dementia you have depends on the type of treatment. And so we want to make sure that people out there that are getting diagnosed with dementia are doing the things that are going to help them the best, because our goal is to make sure that you've got good quality of life and to do as much as possible, early as possible, so that hopefully you can slow down the effects of the dementia that's occurring. So when you think about, your estate planning documents, you want to make sure they're current and up to date, always. But if you've got a diagnosis of dementia, we really want you to have them current and up to date, because it's going to be crucial as the disease progresses to make sure that we're doing all the things necessary to help you through that challenge. And so we're going to walk you through, some different things you need to know, because if we tell people early stages of dementia, not a problem, come in and get your estate planning documents done. Middle stage, it could be a little tricky depending on what type of dementia you have. In late stages, we can't do estate planning documents. It's too late. You're now in crisis planning and other things. And so we don't want that to occur. So when you're talking about estate planning documents, we're talking about decision makers. Who's going to come into play as you become incapacitated? Because when you think about dementia, we're planning for incapacity, okay? Death, easy. Incapacity, so much more difficult to make sure that you are taken care of if you're the person that's been diagnosed with dementia. So when you think about types of decision makers, you're thinking about that executor. In some states, it's called a personal representative of your last will and testament. If you've got minor children, some people with dementia do have younger children. Who's going to be the guardian? Trustees or trust protectors of trust. Maybe you need a rep payee. Maybe you need a representative, a VA representative payee, pension benefits, things like that. Who can make those decisions? For us, the things that are really important are the agents under your financial power of attorney and your medical power of attorney. And so, because we want to make sure that we don't end up in guardianship because your agents aren't able to do the things they need to do to keep you home as long as possible, in-home care, access your assets in order to give you the kind of care that you truly want to have. Maybe you need a representative to be notified if you're late making insurance payments. I was having a conversation with some very lovely ladies yesterday, and we were talking about it because they're both single, they're best friends, they're both a lot older, and so they're worried about what happens if they miss payments and things like that. So there's some really good things you can do. Make sure all your payments you don't want to miss are automatically taken out to your account. Then there's other people that will actually pay your bills for you. So there's lots of options of things out there. We want you to know about them. When you add someone to your bank account, a lot of times they become a co-owner. That really messes up your estate plan, depending on how much money you have in that account. So be very aware of that when you start adding people to your account. And then if you don't have some good documents in place, or if your documents are old or weren't drafted well or weren't drafted by a good elder law attorney, you may end up with guardianship. And that is very much court involvement, can really take a whole lot of bite out of your financial resources. So while you're alive, well, and competent, we tell you, that's the best time to plan because you can legally designate and authorize all your decision makers in advance. So we talked about the financial and the medical, the two primary decision makers. And so there's your statutory dual power of attorney, your medical power of attorney. And for those, if you're on the call or you know someone that has any kind of mental health issues, we also have a mental health power of attorney. So it's really important to make sure that if you suffer from any kind of mental health issues, that you have that separate power of attorney, because it may become necessary depending on how your dementia affects that other diagnosis. So when you start thinking about that financial power of attorney, that statutory dual power of attorney, it authorizes your agents to do anything you could do. I mean, literally, they're stepping into your shoes. It authorizes the agent to make financial decisions. They could open and close bank accounts, sell real estate, defend you in litigation, make gifts, create trust. I mean, think about all those things that an agent can do. It's a very powerful document. We make them powerful on purpose in order to better plan for your long-term care, but you have to pick these people wisely. So specific language, in order to really do good long-term care, you need unlimited gifting. You need the power to create irrevocable trust. Two of the things that we always allow in our power of attorneys to make sure we can do the things that we need to do for you. Your medical power of attorney authorizes an agent to make medical decisions for you if you cannot. They can consent to surgery, they can admit or discharge you from the hospital or the nursing home. They can review your medical records if the HIPAA authorization is included in your medical power of attorney, or if you have that separate HIPAA authorization that we provide as well. Because if you're competent and your HIPAA authorization is only in your medical power of attorney, no one can access your medical records. And so that mental health power of attorney we talked about just a few minutes earlier authorizes the agent to make mental health care decisions regarding care and treatment and service and procedures, because there's a lot of things that the psychiatrist would do that a regular medical power of attorney doesn't allow you to do. So we always make sure that we have those at your disposal if you have that diagnosis. It's hugely important because with this power of attorney, the doctor is very involved. We want them to sit down with the patient and go through, here's some potential treatments. Do you consent, not consent? So that way, both the patient and the doctor are on the same page about what they're signing and what they're allowing the doctor to do if they're not capable of making that decision. We also have your living will or your directive to physicians. I call it your quality of life document. It covers two circumstances and only two circumstances. So if you're terminal, you're going to die in 6 months no matter what. How do you want those last 6 months to be? You can say, I want to just discontinue everything, keep me comfortable as possible. Or you can say, hey, hook me up to life support, whatever you got to do, just keep me alive. The other thing too in that is if you're incapacitated, you can't take care of yourself, you can't make decisions for yourself. I usually equate this to someone who's in the nursing home and doesn't know who you are or anyone else. If they have a heart attack or a stroke, do you want to be kept alive? So for me, it's all about quality of life. And then we make you in hours go back in and really make hard choices. Do you want CPR? Do you want breathing machines? Do you want dialysis? Do you want a feeding tube? Because that's important. If you can't make that decision, a lot of times the facility will tell your family members, hey, if we don't put a feeding tube in, your family member is going to starve to death. And what most people don't realize is when you stop eating, it's your body's natural way of letting go. It's a natural process. And most times when you put feeding tubes in, it causes way more problems than it helps. And it won't eventually prevent you from dying. That last will and testament, most people are very familiar with your last will and testament. Your will names who gets your assets and who's in charge. It only controls what you own in your name alone when you die. It must go through probate. It's a legal process, takes a minimum of 6 months. The probate court has a lot of hurdles you have to jump and timelines to do that. And it's very public. I always laugh and tell people, if you really want to know how public it is, just get on the county clerk's website, type in somebody's name that's passed away. And if they probated their will, you can read their will, their inventory, names and addresses of their beneficiaries. So if they had something you wanted, I can pretty much tell you about the time the beneficiaries are going to get it. So, your will only includes, you only probate for real estate, oil and gas, mineral rights. Everything else you have in life has a beneficiary designation. Take advantage. Check all your beneficiary designations. Checking accounts, savings accounts. If you've had old accounts for a long time, they probably have no beneficiary designations. Go back and revisit everything in your life. Check your beneficiary designations. You never want to probate for a bank account. It's just not cost effective. When you're thinking about choosing decision makers, a lot of people think about family members, maybe close friends. I mean, some of my best friends could absolutely make those decisions for me, probably. And are you comfortable, confiding in family issues and making those decisions? Will they be able to make them on your behalf the way you want them to? Do they have the right character, qualities, or temperament? Which means that in a crisis, can they make hard decisions is really what it comes down to sometimes. And will they be okay with whatever decision they make based on what you have told them that you want? And you always want to make sure they have enough life experience. We never want children, young adults to have to make those hard decisions, if at all possible, not to. You also want to make sure that you keep those family members, whoever's going to be making those decisions, really informed, updated, so because as your life changes and health changes, you want to make sure that whoever's going to be making those decisions really knows as time goes on what your decisions are going to be, especially if they change as you get older. For medical power attorneys, we never do more than one person at a time. I always tell families, no one's going to make decisions in a vacuum. They're usually all going to be in the emergency room or whatever going, what do we do, and talk it over. But because of making sure that there's no fighting and things like that, one person at a time is only appointed on your medical power of attorney. And then is there particular doctors or somebody else that you really want them to be able to touch base with and really get advice over? You also have the opportunity to even think about maybe doing professional decision makers, especially if you've got family members that are in conflict. Maybe you don't really trust that they're going to make the decision that you want. Maybe you're just concerned that they won't make the right decision in a crisis. Maybe you have an estate that's a little larger than you think that you feel comfortable with. A lot of times, we encourage clients to think about maybe professional decision makers when you have children with disabilities, because there's a lot of rules that you have to understand. And but by doing that, you also have to think about how much information, and did you give them enough information for that professional, decision maker to make the right decision? We try to always encourage our clients to do instructions to trustees, put it in writing, send it out to them, update it over time to make sure that they have the most current and up-to-date information so they can make good decisions for you. And so you always want to make sure that, whoever you choose, that you really have a good conversation with them, often if possible. Most of your professional decision makers do charge a fee, so you want to know what that is ahead of time, and then you want to know about what it's going to be when you need them. So the dementia care journey, we tell clients all the time, it's going to be an expensive one. And here's why. In-home care can cost more than $20 an hour. 20 is really on the low end. We're looking at sometimes $25 to $30 an hour, depending on what kind of needs you have. Assisted living in the area can cost more than $4,000 a month, and depending on how much extra you need each month in care could get even higher. And then you look at nursing homes, when you reach that stage, anywhere from $6,000 to $12,000 a month, depending on whether, you're private paying, whether you have long-term care insurance, whether Medicaid is even an issue as far as paying for your long-term care. But we always tell you, there is good news just when you think there's not. and often that there's help. So, it's very important for you to always, reach out and say, what are my options? Because I'm a girl that likes options, and we like to give them to our clients. We want to make sure that you have lots of options. So one of those is, for veterans, if any of you are veterans or are spouses of veterans, we always want to thank them for their service. But there's some VA benefits out there. They just changed the rules a couple of years ago, so you have to kind of really, get up to speed on those. But, if they served during wartime, and they have the countable income and the income and assets below what the VA wants, there's money there. And I always tell clients, it's free money. And so you're like, yay, it's money I don't have to pay taxes on. And when you think about what they had to go through in war, is a lot worse than what we necessarily, I think our guys have to go through here. But still, it's bad all the way around. We want you to have those benefits. You have to be able to meet criteria. You have to be 65 or older. You have to be, has to have some disability for pension itself, with non-service connected disability, so all those kind of things come into play. There's rules, and depending on what you're looking for, the rules are just a little bit different, but not a lot. There's also aid and attendance. So if you're able to, if you want to stay home, and the ability for you to be able to have that extra couple of grand if you're still married, to come in and pay for caregivers is always a huge thing. And so we want you to be able to get as much as you can. So we want you to be able to reach out and get that information to see whether or not you're eligible. When you talk about Medicaid, I'll tell you that Medicaid is the largest payer of long-term care in this country. It's a state federal program. It's a hybrid. Texas Medicaid is actually called HHSC. As far as lawyers, seem like government agencies, we're all about acronyms. And so most people needing long-term care eventually qualify for Medicaid because a lot of them will run out of money. And then here, 2/3 of nursing home residents, definitely are receiving Medicaid benefits right now. And so the Medicaid program pays for nursing home care you have to meet specific requirements for individuals and couples. And so you do not need to be impoverished to qualify for Medicaid. You do not need to spend down all of your assets. You do not need to do a lot of things that are so much myths that are out there. So always talk to a good elder law attorney and let them look at your stuff. The earlier, the better. We want you to plan 5 years before you need it or more. And so with careful planning, getting that 5-year look back period, getting past it gives you the ability to do lots of things. But Medicaid is one of those programs that it is a government program, so they always make it as hard to do as possible. There's restrictions. You have to know when you can transfer, when you can't transfer, who you can transfer to, lots of things that are done. You want to make sure that we always talk to clients about, if you don't have long-term care insurance, be very careful about gifting, period, because we don't want it to come back and have to create a problem down the road that we may or may not be able to fix. So you always want to be very careful about doing those things. When you give assets to the kids, if they predecease you, then you're in big trouble, because then you really can't get it back. And so a lot of times clients think they're doing the right things. They'll, add the children to the house and things like that. And really what it does is you lose all those over 65 exemptions, creates a lot of problems, things that you don't want to happen. So we always want you to get good counseling for that. So if you have good long-term care planning, and so you've got all of your professionals together that you've met with and developed a plan, is definitely what you want to do. And with elder law attorneys, our job is to know the Medicaid rules, to know what we can do, what we can't do. And basically, as far as attorneys, a way to get around the rules, nice and legal. And so we always want to make sure that we do things the way we're supposed to. And we can do that by, how we address the type of asset it is. And so there's a lot of good planning that can be done. And so when you work with an attorney that knows these rules, they can develop a plan that can help you down the road. We tell people, when you're married, we can help you, we can protect almost everything you have. When you're single, we can protect about half of it. And and that includes, exempt and don't talk about non-exempt assets. So you got to keep that in mind when you're thinking about, what is my long-term care plan going to need? How am I going to pay for that if I need it? A lot of people laugh and say, I'm never going to need a nursing home care. But we always want you to plan just in case. So when you think about accountable resources, you're looking at bank accounts, checking, savings, money markets, CDs, savings, stocks, mutual funds. And a little known thing is cash value in life insurance policies. And a lot of people don't realize that they have some of their insurance policies have lots of cash value because they've had them over time, when whole life was what you bought. You either bought term or whole life. Universal wasn't even in the picture back then. And they accumulate a lot of cash value. So it's real important to make sure you know that, because you have to do something with that too. So, cash, retirement accounts, if you're not collecting required minimum distributions, are accountable. We know what to do about those too. Motor vehicles can't have more than one per spouse. So if you have a few extra, don't get to keep those. In trust accounts that the applicant, the person that's applying for benefits, can access. So you want to be very careful about how you come into money to make sure that doesn't create a problem. More than one house, more than one residence, annuities, that kind of thing. Now, they do give you the benefit of not trying to take your cemetery lot. So I guess that's a plus, right? Term life insurance is not countable. Cash value of life insurance that is less than $1,500, not countable. And if you have income producing property, like you have rental properties that are essential to your self-support, like they're paying enough money to keep you, paying the bills and things like that, you can probably exempt those as well. Non-countable resources, your homestead, even if your homestead is vacant, like you're in the nursing home, as long as you have the intent to return home, and I guarantee you everybody does, regardless, then your house is protected. Depending on how much land is around the house, we can protect a lot of that as well. And then a lot of times, even if you just have a life estate interest, protected as well. So lots of cool things we can do. Single persons on the long-term care Medicaid benefits have to pay all of their monthly income to the nursing home, minus that personal needs allowance, which is $60 right now. Married persons, maybe not, depending on the income between the two of them. And so there's deductions that are allowed. So there's really lots of rules. So we want to make sure that you're aware of all them. And everything depends on what assets you have, how much are your assets, what your income is, for just about every program out there, whether you're talking about VA or Medicaid. So there are steps to consider, okay? And you need to take charge and you need to get smart about it. So that's tons of the reasons why we do all these workshops and everything, is because our job is to educate you as much as possible so that you don't get caught unaware. We want to make sure that you're getting everything that you're entitled to and that you're taking advantage of everything that's legally out there. So some of the steps for those of you that are on the workshop today, on the conference, we want you to learn to become a skilled dementia caregiver. So we want you to be just as, being able to do things as well as you could do. We also want to make sure that your loved one takes immediate steps to put the appropriate plans into place to protect them and you. If you're one of the kids or a family member, we want to make sure that you're protected as much as possible. And you have to think about, for every additional month that you're able to keep your loved one at home, that's potentially an extra $6,000-7,000 in your pocket of your hard-earned savings. So we want to make sure that we can do what we need to do, but we also don't want caregiver burnout. We don't want the family members suffering, trying to keep you at home, trying to save money. So there are some things that we can do to help them, help you, help them, depending on what they need. And so, because for us, caregivers are so important, we want to make sure they're taken care of as well. So we call what we do a lot of times is our dementia long-term care plan. And so we're looking at legal and care strategies, kind of a combination to kind of help y'all walk through the process. So we want to make sure that that someone can provide great care for their loved ones, really understand the care needed as the disease progresses. I've having to have conversations with one of my family members because they're not providing enough care. So we need to fix that. You're like, nope, can't leave them at home. You've got to have more care. And you need to keep the same schedule, whether it's Monday through Friday or Saturday, Sunday, they need to be on the same schedule. And so we want to make sure that, the caregivers are taken care of, that they're getting relief and respite and things like that. And then knowing who to call, if you run across a problem, put you in touch with all the right people that you need to. And to make sure that you put a plan in place that provides the care without going broke. Just so you know, we have some free books, and so we give these away like crazy. So I want to make sure that if you don't have one of the books, one of the books is You've Been Diagnosed with Alzheimer's. The other one is for caregivers. They're free. We want you to take advantage of them. You can give us a call, send us an email. We want to just give them out. It's a lot of good information that really helps people. Because we want to make sure that they're getting everything that they need education-wise so that they can make good decisions for themselves and their family. Alzheimer's planning, when you're thinking about dementia and Alzheimer's, you want to make sure as far as legal planning is who's going to assist those clients daily, who's going to be there, who's that person or persons. We always want you to plan ahead for care. What is it going to be? What does it look like? How are we going to pay for it? Manage stress and prevent caregiver burnout. Two hugely important things because we love our caregivers and we don't want anything to happen to them. And then really be able to be a good resource for support groups and community resources and things like that. And so, for us, we just like to say, and I'll just toot my own horn here just for a minute, we're always put us on here to make sure that because we're doing this, that you want someone, whether it's us or someone else, to make sure that they're knowledgeable about the legal planning and the asset protection and what benefits and community resources and things like that, that your plans are individualized based on it, and you get quality of documents and peace of mind. And we look at the attorney's role, it goes well beyond providing legal services. When you see that attorney and counselor at law, we also do a lot of family counseling, helping the families get through their need. And when you lose that independence, what do we do? And how do we help caregivers and financials and really just try to be a resource, for our clients. And everybody's goal should be to age with dignity. Okay, that's everybody's goal. So we want to provide you with options. You need to have someone that's going to identify the care for you and help you manage your assets and really place you in charge of your future. You've worked hard for what you have. We want you to leave a legacy for your loved ones only if that's the plan. A lot of clients I laugh and tell them they're like plan A. Plan A is when the second one passes from husband and wife, the last check they write bounces. If you raised your kids right, they don't need it. The goal is to make sure that what you've worked for benefits you the way you want it. And so for us, if you want to schedule an appointment, visit with us, talk to us about how we can help you. Reagan will put the online, you can sign up online. She'll put it in the chat. And so for us, we see clients, any way they need to. We review documents. We want to make sure that your planning is correct and give you that peace of mind that you have worked so hard for. And I'm thinking that there's this is the one I wanted. And so I wanted to make sure that while y'all had me on here today, and because I did this a little bit quickly because I didn't want to run out of time and I wanted to be respectful of your time, but I also wanted to make sure that if you have questions, we want to make sure that, that we can answer them for you. I think that I was under the impression that, yes, we are able to answer questions. Is that right, Catherine?
Absolutely.
And so we definitely want you to be able to do that. And so.
Can you hear me, Kim?
I can hear you fine.
Okay, great. Yes, everybody, you're able to put your questions in the chat if you want, or you can unmute yourself and just ask him directly.
Go ahead.
And I'll start off with a question, Kim.
Sure.
How do you know if it's too late to start doing these documents when you've got somebody that has dementia? How do you know when that critical time is, that it's too late?
A lot's going to depend, Catherine, on how they are when they're in my office. When you sit and talk with somebody, some people, depending on how far along they are with dementia, you can tell in the first 10 to 15 minutes. I've had some clients that I've spent an hour, couple hours with, and couldn't tell you they had dementia. However, because of the family dynamics, we send them back to the doctor for a note that says, just have the doctor write a note that you're competent to sign legal documents. And so, because we do that a lot to protect them from other family members, because as long as the doctor said they were competent, we bring them right back in as soon as, right after that, and sign their documents. I've had doctors tell me when I thought it was a little beyond their capabilities, that as long as they understood what they were signing at the time they were signing it, they were fine. And so, so we try to be careful, because as lawyers, we're not allowed to have someone sign documents if they don't have the capacity to do so. So we're way more cautious than this particular doctor, way more cautious than this particular doctor is. But you always want to make sure that, that we try to do as much as we can. And so, and you just want to do it earlier than later, so always earlier than later. And so no planning at all is just a plan for disaster.
Good, good. So what I'd say to everybody out here, if you haven't gotten your documents in order and you say, I'm perfectly fine, go ahead and do them now. Don't wait.
Yes.
Don't wait, because you don't know what tomorrow's going to bring. So just go ahead and get them done now. Like I said before, 18 to 80, it doesn't matter. Get your documents in order. And then once you get them in order, you need to review them every year, right, Kim? You need to make sure that things haven't changed.
We see clients about every 3 years. Usually we try to bring them in for review, but as they get older, so we see about every 3 years till you hit your 70s. And then I want to see you about every couple of years. When you hit your 80s, I want to see you every year. The reason we up it faster is because we're looking for elder abuse, to be perfectly honest with you. We're looking for people that are taking advantage of them. Elder abuse is on the rise. If we can find it, stop it, do something about it, we want to. As you get older and start to decline, if that's what happens to you, a lot of your financial entities won't take old documents. So the more current they are, the easier it is for that agent to use. Like our statutory durable power of attorney, our legislators have updated that for every 2 years for the past 6 years. So they play with it, they tweak it, they make some changes to it. And so they were just finishing up legislation. So Lord only knows what they've done. I've kept some track with some of it, but I'll get most of it in August, the update. Still they create havoc. We're always thankful they're only there every other year. So, because some things are very beneficial. Some things are like, well, I'm not really sure why they did that, but
So I didn't realize that there were that many changes that were being made that would affect your documents.
It's surprising. Medical power attorneys have been pretty good up until I think the new one, the change they made to it was effective January 1 of 2018. And so we had clients coming in 2017 where the new financial power of attorney was effective September, but the medical wasn't effective till January. That's what I'm talking about, the craziness, instead of them both being effective at the same time. So it would have been easier, but you never know. And so I can't see the question. So I'm hoping that if anybody has one, they'll pop on. I'm game.
Oh, wait a minute. Somebody just put something in. Okay.
Let's
So
see.
Tiffany, Tiffany is asking, I'll just read them to you, Kim, if that's okay. So Tiffany is asking, she says, my dad went into the hospital and now is in a skilled nursing facility. He has a house, a vehicle and 50,000 in the bank. We were told to spend the money fixing up the house and vehicle and 50,000 in the bank. We were told to spend the money fixing up the house and vehicle and hurry before 20 days is up. Is there any other way to keep the money without spending it so fast?
Once they're talking about the 20 days, Medicare pays for the first 20 days in full. Days 21 through 100, they only pay a 20% copay. So now, if they're eligible for Medicare during that time period, days 21 through whenever, they won't be qualified for Medicaid. So you really, Tiffany, you really want to find out from the nursing home if dad is no longer qualified after those 20 days. Now, having said that, that 80% copay is going to run you about $150 a day. It's not cheap.
Yeah, they said that that he is qualified for all up to 100 days, but the copay is going to be $14,840, I believe.
Yeah.
Wow.
So one of the things is, while they tell you that he's eligible up to 100, I'm surprised they did that, because no one ever does that. Very few people make it to 100, because if your dad stops improving, they will cut him off right then. With single people, is your dad married or single?
He's single.
So with single people, we can protect about half of it if you do nothing else. About half of it we can protect. That means there's nothing done to the house, nothing done to the vehicle, anything like that. You can protect the home with the life estate deed, and you want dad, if he's capable of signing that, to sign that right away to protect the house. But also know, once he goes on Medicaid, somebody else has to pay the bills of the house. Somebody else has to pay the car insurance. Somebody else has to pay those things. So always make sure that as you're doing things, like when you do when you protect half of that money, you can use that half to pay those things while dad's in the nursing home. So there is something that can be done, and you do want to do something very quickly, but it doesn't necessarily mean you have to just spend it all. Okay. Because if he's not eligible for Medicaid and he's only eligible for Medicare, that means you still got a bill coming. And protecting that house protects you from probate, protects you from Medicaid estate recovery. So doing that, minimum that. And so I would encourage you to get in. If you haven't seen a good elder law attorney, or if you want to come see us, get in right away. We'll get you in right away, because time is your enemy when you're in crisis planning. So don't hesitate to do that. Rosinade, that's beautiful. Life estate deed, also called a ladybird deed. It's a deed that says the house is mine. I can do anything I want to while I'm alive, but when I'm gone, it's going to my beneficiaries, and you name those beneficiaries. It avoids probate. Basically, all we do after you pass away is file an affidavit of death, avoids probate, avoids 99.9% creditors. So it's always a good thing. And the bigger thing is it avoids Medicaid estate recovery. And so hugely important. Let's see. That even though you have no idea what dementia is, why is put in place your will? Yes, Sid, you're absolutely correct. No one knows if you're going to get dementia. And the reality with dementia is a lot of times it occurs and the people around you don't really notice for a while. Because people kind of equate it as, oh, I'm just getting older and, I'm forgetful, Heck, I'm a young girl, and my staff found my phone one time in the refrigerator because I set it on the shelf while I was loading drinks into it. So they made fun of me a lot. I promise you I don't have dementia, but every time you do something like that, people are going to think, oh, you're just, losing your keys, that kind of stuff. You always want to have your documents in place just to make sure and keep them current and up to date. And I think, Rosinade, you asked the difference between a POD and a ladybird deed. Like a POD, payable on death, transfer on death, beneficiary designations. All three of those are the same thing. Those are all for financial accounts. The ladybird deed, life estate deed, is for real estate. Okay, real estate, oil and gas, minerals, so those things. So they're different things depending on the type of asset that you have. So your beneficiary designations control on all your financial, life insurance, those types of accounts. Ladybird deed, life estate takes care of real estate. All right, come on, guys, be brave. Transfer on death deed, just so you know, Rosinade, the transfer on death deed, the Supreme Court has pulled that off there as a document that they were encouraging. Transfer on death deeds, while title companies like them a lot, there is a 2 years where the title company will not give you title insurance because creditors have up to 2 years to come get the house, basically, to sue you, to get their money based on your real estate. So we have never used the transfer on death deeds. As soon as they came out, we knew they were going to be bad when you just read the codes. So even the Supreme Court's figured that out. It was nice enough them to read it as well. So they pulled it off. They don't even say it's a document someone should use. And so, and Sid, you're correct. It's not necessarily a matter of the size of your estate. It has everything to do with what's in your estate. You don't own a home, don't have oil and gas, mineral rights, you probably will never probate your will. And so, but we always tell clients, even if you don't own real estate, we want you to have a will. The reason being is what happens if the last thing you do is run a red light, kill a family of 4, or somebody runs a red light and kills you. Your executor needs to be appointed in order to sue the insurance company. Maybe it's medical malpractice, things like that. So you always want a will. I hope to God you don't have to use it in those circumstances, but you always want to have one. If there's a potential family member that's going to cause problems, we like trust planning. Anytime you've got problems, trust planning usually can solve most of it. Anything that avoids probate usually gives you better options to protect the family because probate is very public. You have to notify a lot of people. If you've got problem beneficiaries that are named as beneficiaries, you still have to notify them stuff. The more things you can do without going to probate usually lessens the probability of problems. Depending on the problems, we like to sometimes address them, get them taken, you just open it up, deal with them, and let it be done. Because depending on what type of problems they are, it's always better while your parents are alive to deal with them versus not dealing with them. Because what happens is you have people that you get to deal with them after your parents are gone. And so we try to avoid that if at all possible. Try not to make it painful for your parents, but we also don't want to have that problem continue down the road. And for you as well. And so, like I said, it just depends on what your family members have, depends on and where it's at, depends on what we do to minimize that risk.
Kim, I think you missed one from Patricia a little bit earlier. It says, does probate life estate deed protect residents only? My mother lives in an apartment but has a rental property.
So the life estate deed will protect the rental property from passing through probate and for Medicaid estate recovery. In order to truly protect that rental property, we have to be able to show Medicaid that rental property is necessary. She needs that because that's her income. That's her way of making a living. It's a harder sell sometimes, on that. So if the lease is running out and mom is declining, I'd move her out of the apartment and put her back in the rental property and claim it as your homestead. And so she only has to be there a day, but you got to have all the paperwork. And so keep that in mind as things come out. Maybe, living in the apartment may not be, the best thing for her. I know the income is probably going to be painful, but depending on where she's at would depend on what I would do. And then I think there was one. Patricia had asked about, we use life estate deeds for a lot of things. We use them for rental properties. Now out of state depends on whether or not you're able to do life estate deeds in other states. Some states we've had no problems with, some states we run across problems. Just when I thought I had one, I think Tennessee was a problem state. The attorney kept saying, well, we can't really do that. I'm like, why? Can't really do it. I can gift it, but I'm like, no, there's a huge step up in basis if mom gifts, so it was just going to be a problem, so there are some states out there that don't have it. You're best to find an attorney that can tell you that. And luckily my new attorney is licensed in Louisiana. So give us a call. I'll have Dana answer that question for you. So.
What complicates it more is my mother actually lives here in an apartment, but the property is in Louisiana.
Yeah, sometimes with real estate in Medicaid, it's harder when it's out of state, but sometimes you can put it up for sale, and that will exempt it for a while. And so that does make it more problematic because you really want mom here, close to you. And it may be that at some point in time you sell the property in Louisiana, unless you're attached to it like it's family property, use the money to buy her a condo or something here so that you can protect that. So a lot of times it just depends on how attached she is to that property in Louisiana, as far as, does she need the money, or is it just family property and she doesn't want to get rid of it? We'll make the decision about what you need to do as mom, if mom declines, so that the best way to do to protect the most you can protect. And that's really the goal. And so in that aspect.
Right. And there's one other question. She also owns a piece of property in Louisiana. It's a lot. And the value of it is, well, especially with the real estate market, is really questionable. So how do y'all determine that?
So a lot of times you can do it by, like in Harris County, we just use CAD because they're pretty accurate. Not Galveston County, because if you've seen what they do, and so they're a little high. But Harris County, the appraisal district is actually pretty good as far as values. They're pretty close. You can have it appraised, whatever kind of value that Louisiana gives it, if they do that sort of thing in Louisiana. And unfortunately, I can't answer that question for you.
Yeah, they don't have their taxes, their property taxes are unbelievably low. So you really can't go by that. And I guess we could get it appraised.
You can get it appraised. Most of that doesn't cost too terribly much. Sometimes realtors can do market analysis if they've been around for a long time, but a true appraisal will give you the right amount. If you're trying to sell it, use a realtor to give you market value, because they're going to know what lots are going to go for in that area. And a lot just depends on how attached mom is to the property. And so, because you could sell all that, buy her a little townhome or a condo close to you, and then you could protect all of that. So it's really just a decision that you have to make as a family over, what do we need to do and how do we need to do it? And it's just a matter of sitting down and just kind of going through that stuff, but mom has to be a party to that conversation because, it's her stuff. So
Right.
make sure, Patricia, in your aspect of it, I would probably want mom to sign a power of attorney here, but I would probably have her sign a power of attorney for Louisiana as well. And one doesn't revoke the other one, because Louisiana law is so different than the other 49 states.
I know.
Language,
law.
terms, everything. And it's so different. So I'd probably want your mom to have both to make your life easier for dealing with the property in Louisiana.
Well, that brings up another question. Her last will was years ago done in Louisiana, and she's talked about getting one done here. Would that override the Louisiana will?
If all of her real estate is in Louisiana, I would update her Louisiana attorney, her Louisiana will. And so,
so the fact that she lives here really doesn't have any bearing on her Louisiana property.
You're probably going to probate in Louisiana and not in Texas. And so now, having said that, I'll have to confirm, because I don't know 100% about Louisiana, but there are some states that require you to probate in Texas before they will let you do ancillary probate in their state, because even if the property's there, because mom would have passed away here. I would have to find that out from you. Like I said, Dana in my office is one of our new attorneys, and she's licensed in Texas and Louisiana, and she could answer that question for you. And I hate that she's not on here instead of me. And so, because that would be easy to answer.
Yeah. Okay. And it's Dana, you said?
Yes. Okay. So, and in Sid, I think most of our wills are pretty basic, to be honest with you. We don't do there's not a whole lot of things you can do in a will as easy as you can in a trust. In a basic will, just says whatever I have, I leave to whoever, and they get it out right. There's no problems, things like that. Your beneficiaries are all adults over the age of 25 if I'm drafting. But there are wills that do a lot of other things, that do marital trust and things like that. So just a basic will that says whatever I have goes to my beneficiaries. That's basically most of what you would consider basic, I think.
Okay.
All right. I'm thinking if nobody's asking.
Any other questions out there before Kim takes off? This has been very informative, Kim. Thank you so much. As always, you deliver a wonderful presentation, and you are just a wonderful resource to have. Oh, we've got another one.
And so, yes, Karen, we've done a lot of probate litigation. We've kind of, we're not doing a lot right at this moment, and just kind of taking a break. It takes a lot out of you to litigate. We have some very good referral sources, so that's what they do all day long, every day. They enjoy it. And so I did a lot of litigation probably about the first 12 years of my practice. And then while strategy is a lot of fun, I don't enjoy the court process. So families can be so cruel to each other, and it's just sad all the way around. And so I had to endure it in my own family, so it was very painful. And so if you have to go through that, Karen, I'm going to tell you right now, I'm sorry ahead of time. But we do have some great referral sources for just about everything. And so, most definitely.
I have another quick question. You mentioned trust. Are these revocable trusts?
We do a lot of different types of trust. Revocable trust, if paying for your long-term care is not necessarily an issue, you got plenty of money, you don't care about private paying, or you've got long-term care insurance. We use an income-only irrevocable trust to protect those non-retirement assets that, but you still have to beat the 5-year look-back period. So we want you to put those in that trust, as time goes on. And the best thing to do for that is rental properties, investment accounts, money markets, money sitting in the bank, not necessarily a good thing unless you don't need it. But things that produce income are great to put in this particular trust. And so, and Karen, if you need an attorney, just call the office when and if the time comes, and we'll refer you out. We've got some good ones.
So to get an appointment or a consultation, we just call your office?
You can, and I'm assuming that Reagan is still on. Reagan, if you're still on, drop the Calendly link in the chat again for me. I can't see who's on.
I'll copy and paste it.
There you go. Now, I told Reagan to get on for this reason.
Yeah, she put it in there, but she may not be here now. So
yeah, she put it in there.
There
now,
it is again. Okay. So there's the Calendly link, so you can make an appointment with Kim. And
okay, so the ones in blue are the ones available. Is that how it works? The days in blue.
I'm assuming so.
Reagan says yes.
Yes, Reagan said yes.
Okay, and this is with Adam Hunley.
If you need Adam does all our estate planning consults. So if you
need an elder lawyer.
So if you need an elder law consult, you need to call the office. And
call the office.
And
okay.
Yes. Now, somebody asked me about the 5-year look back rule. Medicaid has a 5-year look back for transfers. So if you gifted money to somebody within the 5-year time period of you applying for Medicaid, you've got a problem. So depending on who you gifted, how much, what you gifted, depends on whether we can cure it or not. Otherwise, Medicaid is really, really mean. In the old days, if you gifted something 3 years ago, they'd start the penalty period from the date of the gift. So a lot of times you were past that when the time came to apply. Then Medicaid came back and said, no, we're going to apply the penalty from the time you apply. So then the penalty goes forward. It's an ugly penalty because you just kind of get double penalized, I think. But they do it. So if you can get a transfer, anything that's transferred 5 years before someone needs Medicaid, you don't even have to tell Medicaid about it. And so, which is why we like setting our trust up, funding those trusts, and getting past the 5-year look back period. And so, because we can use other funds to pay for that long-term care till we get past that 60 months, and then we can apply in month 61. Hopefully that helps. Well, I just want to thank y'all for having me. The other thing too is I want to tell y'all have a great weekend. The weather is supposed to be fabulous, and it's supposed to start raining again the following weekend. So I want y'all to really have a good weekend and enjoy yourselves. And thanks to Catherine and Care Partners, and you guys are great. I appreciate you having me on. I love doing this, so it's always a lot of fun for me. I'm blessed that I get to meet a lot of really, really good people, And so it makes it even more fun.
Thanks, Kim. We really appreciate it.